Diane, nice to meet you. Yes, sorry.
Phones are muted or turned off or whatever. All right. State of Michigan Court of Claims is now in session with the Honorable Brock A. Swartzel. All persons having business here draw near, give attention, and they shall be heard. God save these United States, the state of Michigan, and this honorable court. Please be seated. All right.
Good afternoon. My name is Brock Swartzel, and I'm a judge on the Michigan Court of Appeals, sitting by appointment today as a judge on the Michigan Court of Claims. I'd like counsel for the parties to put their appearances on the record, please. I'm going to correct you already this afternoon. Gotcha. Fair point. Thank you. We are here this afternoon on the parties' cross motions for summary disposition under MCR 2.116C10. So that we can best use our time this afternoon, I want to make clear that I have reviewed the parties' respective motions, responses, and replies. I reviewed the pleadings. I reviewed Judge O'Brien's September 2nd, 2021 opinion in this case, and I've read the relevant law, including the applicable provisions of the Administrative Procedures Act and the Safe Drinking Water Act. I have also had the assistance of a bench memo prepared by my law clerk. This is all to simply say that I am well versed in the background and posture of the dispute and the parties' respective positions. So I strongly advise that the lawyers that we not waste a lot of time going over how we got here. Let's just get straight into the critical points of your positions. Given that we have cross motions on the docket for today, let's handle the arguments like this. Let's start with the department because you filed your motion, I think, a day first, so they get to go first. Cover both your motion and the response to 3M's motion at the same time. Then we're going to hear from 3M, where you can argue your motion as well as make any responses that you would like. Then we'll have time to go back and forth to reply. I'm not hung up on, let's put it this way, we will be here until everyone has had their say on everything that they want to make a say, that you want to make a record on, okay? Also, unless you can convince me otherwise today, I'm going to order a supplemental briefing on whether 3M has standing to bring its claims in this lawsuit. The rules at issue apply primarily to public water systems, and I don't see any allegation or evidence to suggest that 3M owns or operates a public water system. I do understand that as a manufacturer, 3M has some practical concerns about its exposure with respect to groundwater standards, but how 3M has standing to challenge administrative rules governing public water systems when it does not appear to own or operate a public water system is not obvious to me. And if 3M standing is somehow related to the Safe Drinking Water Act's regulation of waterworks systems, then I'd like that explained a bit more for the court. Similar to subject matter jurisdiction, the question of standing is not something that this court is inclined to accept based on the concession of the department. So I need to be convinced that 3M actually has standing in this case rather than just brushing the argument to the side. And I want to be clear, I am not suggesting that you don't have standing. It's not obvious to me. And I'd like some cogent explanation of why. So each side is going to have 14 days with 10 pages from the date of the written order to address the issue. And I'll probably get the order out today or tomorrow. Briefs due at the same time. I don't want a bunch of back and forth. It's just, just address the issue. Finally, I'm going to make a plea as a generalist judicial officer. Other than MPART, which is MPART, JCAR, JCAR, PFAS, PFAS, and APA. Please do not use acronyms during the hearing today. It would be nice if a regular person could read the transcript of today's hearing and make sense of it without an executive branch acronym cheat sheet. Does that make sense? Thank you. I get lost when, you start using RIS and all this stuff. So with all of that said, defendant, please proceed.
Here today on 3M's challenge to the standards that Eagle set in rules establishing the levels of PFAS that can be detected in drinking water.
And just for our court reporters' benefit, Eagle is EGLE.
Yes, thank you. All right, see, personal.
You already violated my
the
request.
orders. The last two administrations, first Governor Snyder and now Governor Whitmer, understood the importance of these rules, and they pushed hard to have these rules enacted because of their concerns about the threat posed by these toxins and the need to have them further regulated. And these rules were enacted as a result of significant effort by Eagle. Not just Eagle, it was the Department of Health and Human Services, it was MPART. There were the Environmental Rules Review Committee. There were literally dozens of work groups that were working on this project to understand the scope of contamination caused by this contaminant throughout the state and the harms that it represented to the public. And that's important because this was not a rush to judgment. This was a multi-year effort that started in one administration and ended in another administration. And everybody understood the importance of these issues. Everybody knew that 3M was waiting off in the wings, was going to challenge these rules. That's what they've done to every other state that has attempted to regulate these contaminants. The point is, everybody understood the importance of what they were doing, so no shortcuts were taken.
In your opinion, was 3M involved in the administrative rulemaking process?
Absolutely.
They were.
Absolutely and unequivocally. And that's an important point because they were heard out. They participated in the public comment. They submitted, I think it was 71 pages of comments to Eagle. Their concerns were heard. They had a separate meeting between MPART representatives, Eagle representatives, and a toxicologist at Eagle that assisted the science work group. They got an hour to present all of their concerns in a private meeting. They were heard out. Those comments that were made during the public comment were summarized and reviewed by everybody at Eagle. Eagle had those comments also reviewed by a work group that was specifically at DHHS, Department of Health and Human Services, to consider these toxicity issues. They were considered by the science work group. And then, even though the APA only requires Eagle to provide a summary of the public comments, they went beyond that. They took those comments and they had a presentation in front of the Environmental Rules Committee, which has been appointed by the legislature to oversee rulemaking within Eagle. And they discussed all of these issues. So there was plenty of input by 3M, but its comments were rejected as being contrary to the science and known facts. And that was not a surprise to anybody, let alone 3M, because they followed the same path in other states. And those other states and federal agencies have also rejected those concerns.
Did the proposed rules go to JCAR?
Yes,
and
they did.
And go through the regular JCAR process?
The standard procedure, all of them.
Okay.
Yes.
And then, if I recall correctly, the promulgated rules took effect on, was it August 3rd of 2020?
Yes.
So they've been in effect in this state for almost 2 years.
Correct. Yes. I think what's important is you look at the case law, and the fact of the matter is Michigan court after Michigan court of opinion has established the rules that there's great deference provided by the judiciary to state agencies in that rulemaking process.
So one of the issues that plaintiffs raise, 3M raises, is with regard to necessary. The water standards necessary to protect the public health. I think they take issue with whether these rules reach the proper necessary standard. Can you address that specifically?
Absolutely. We think there is no reasonable argument on that. I'm going to say it. The Science Advisory Work Group was established and directed to look at all in place and proposed state and federal regulations relating to PFAS. And they were so advised that they had to identify the most scientifically defensible public health toxicity values, exposure assessments, and risk methodologies to set forth health-based drinking values for PFAS. And that's exactly what they did. They brought in these national experts, paired them with state experts from Eagle and DHHS, and they undertook that process in the report, which is attached to our brief. It goes through in excruciating detail exactly what they did, which standards they found to be most convincing, and then identified the reports that they relied upon for setting those values. And they identified 7 PFAS analytes that they believed information existed to show that they presented exposure to those 7 contaminants posed a risk to public health, that there was defensible scientific evidence to establish that.
So, and obviously 3M's lawyers can correct me if I'm wrong, but the way I read their argument with regard to this term necessary is that they almost are asking this court to impose a requirement that the department somehow optimize and pick the perfect, the most optimal standard to protect the public health with regard to drinking water. Do you know of any case law with regard to how this court is to interpret the word necessary within the context of this particular act?
No, there's none.
Okay.
There's none.
So why do you not think, I presume, that the department has to pick the most perfect optimized standard versus, maybe a range of reasonable standards that meet the necessary requirement?
And because the APA doesn't require it, and that's not language that's in the Safe Drinking Water Act under the rulemaking grant of authority. It just says standards that are necessary to protect public health.
Well, I guess, can you elaborate a little bit more on the department's interpretation of the word necessary? Because I was on a case in my day job as a Court of Appeals judge, Township of Hopkins, where we had to interpret the word necessary. And we made clear that it can have different meanings depending on which statutory construct or context you're in. So tell me, in your opinion, what does necessary mean in this act?
Well, in this act, we view it just should be interpreted as everyday ordinary meaning, which we set forth in various dictionaries. We know the Supreme Court has also looked at this issue, and they use some terms that I know 3M cites in their brief. I think the key about that decision, and what was that? That was the
Was that the federal question case?
Yes.
In dealing with the delegation doctrine?
Yes.
Okay.
And if you look at it, they said, necessary means, I can't remember the exact phrase they used, it set forth a series of terms, but then they applied it. And when they were talking about public health, and they said in the public health contents, it has a very broad meaning. And that's what we're saying here. Even if you take a narrow interpretation of it, protect public health. It doesn't say protect some public health, it says protect public health. And that's what happened here by picking these health-based values. These aren't out of the ordinary. Health-based values are what are used in the drinking water construct. It is what the EPA used under the Federal Safe Drinking Water Act to establish their contaminant levels. So it is not out of the ordinary to use these health-based values, it's standard. And that's what this work group found. They found that there was scientifically defensible data to show that exposure to these 7 PFAS contaminants that they identified create a risk of harm to the public. And they set those health-based values then at the level at which that data also established there was not a risk. So that was the data they used to determine these standards. Was there risk to the public? Because that's what they're directed to do. They're directed to protect the public under the Safe Drinking Water Act. And that's why they used those values. And that's the direct connection between science and the rulemaking authority under the Safe Drinking Water Act. Science says this is the level it should be, and that's what they use. There isn't a directive that you consider the cost under the Michigan Safe Drinking Water Act. There isn't a directive that you compare different levels under the APA or the Michigan Safe Drinking Water Act. As we said, they did actually do that because the Science Advisory Work Group looked at all the different standards that were out there. So they did look at the other standards and decided this was the information, these were the facts that the data established were the best scientifically defensible facts.
Now, this does seem to be an area of which the science has evolved and probably will continue to evolve. How does the department's rulemaking take into account the fact that evidence and the science, the scientific conclusions may change over time as more and more evidence is gathered?
And that was a question that was raised in front of the Environmental Rules Committee. And Eagle has said that they will continue to follow the data and establish different standards as further information becomes available, whether it's up or down. I mean, you're right. The trend is clearly down.
I don't know what you mean up or down. You mean the
Higher
standards
levels-
becoming tighter?
Yes, exactly. And the information is clearly showing more and more that these contaminants present a greater and greater risk at lower and lower levels.
I got you. Okay.
That's the trend that's being established. So we've taken the data that currently exists, it's what we have, and that's what we use to set those standards. It's likely that they'll continue to move down. In fact, we think it's fairly obvious that in the near future, the EPA is going to announce standards that are going to go down much further. So yes, that will probably be the trend, and Eagle is committed to continuing to follow science and establishing their standards. Because again, they're directed to protect the public. That just doesn't stop at some point. You have to continue to look at all the data for not only PFAS, but any chemicals that are out there. So we think the use of these health-based values and the work group's report directly connects the standards that were set by Eagle and the rulemaking authority. Now, they also make the argument in their substantive challenge to these rules that they were arbitrary and capricious. Those are fairly broad standards to say the least. If it's arbitrary, you have to have acted without any basis in fact, any principles in mind. And if it's capricious, the case law says they have to be subject to change. And we know what principles Eagles relied upon. They relied upon the work group's report. So the principles are known, and when they're known, that gets you over the capricious standard, or excuse me, arbitrary standard. And with respect to the capricious standard, these rules are set. The standards are set. They're not going to change unless in the future Eagle decides to change the rules. So they're not subject to change. So it just gets beyond the arbitrary and capricious test. I think that gets you over the substantive objections that they made to the rules, and then they also objected to the procedural, and their procedural objections focused on the regulatory impact statement. And there is no Michigan court that has ever invalidated rules based upon an allegedly deficient regulatory impact statement. In fact, the only case law is to the opposite. And that's Judge Murray's decision in the Oakland County case. Now, the APA just requires each of these estimates or standards to be issues to be addressed. And there's no doubt that Eagle addressed each of those issues. And if you take a look at that regulatory impact statement, it wasn't a sloppy job. It wasn't a half-hearted job. It was a thoughtful process that they went through. Each and every one of the issues was addressed in detail. And, again, we go back to the fact that courts have typically deferred to agency rulemaking and have not second-guessed fact-finding by agencies in the rulemaking process. And that's exactly what they're asking this court to do. No Michigan court has ever done that before. We think that Judge Murray got it right. Eagle did exactly what it was required to do under the rules. There is not any justification for this court to take or requirement for this court to take an analysis, undertake an analysis of each of the statements in that statement. The fact of the matter, it requires estimates. That's what Eagle did. They're all set forth in there. And we think Judge Murray got it right in refusing to undertake the kind of intensive analysis that 3M is asking this court to do. Otherwise, any regulatory impact statement, sorry, that was another acronym, is going to be subject to challenge. There's only so many pages you can put in. Any challenger is going to be able to take a look at what is set forth in there and find something that they think was or should have been addressed. Well, that would make all rules subject to this argument.
So what is the court's role with respect to regulatory impact statements? If it's a one pager, that clearly seems to have been kind of phoned in on the last day of the person's job or something, do we have to defer to that? Or I mean, like, what is the court's role when looking at the regulatory impact statement here?
I think you really just have to take a look at it and come to the conclusion that a good faith effort was put in by the regulatory agency. I mean, you're right. They can't just blow it off. I think that would be improper. There has to be a good faith approach to it. And I think that's more than what Eagle did, just even a cursory review of that.
So if the statement indicates that facts were gathered, evidence was gathered, public comments were taken into account, scientific expertise was applied to the evidence, and apparently reasonable conclusions drawn therefrom, that's sufficient.
I believe so. Yes, exactly. As I say, there's no support for their position. The court should take this intensive review. And I would say the objection, with respect to the objections that I anticipate that they're going to raise with respect to the regulatory impact statement, they make contentions about how conclusions reached by Eagle may have been wrong, but they don't submit any evidence to support the assertions that they're making. The fact is, Eagle did make a good faith effort throughout this process. We think the data is there, and without any admissible evidence to show that any of it was incorrect, there's really no basis for the vast majority of the attacks that they made. So I think I addressed the highlights that I wanted to address, and if any more questions come up, we'll be happy to address them at that time. All right.
Okay, thank you. I appreciate it. Good afternoon.
If it would be all right, I'd like to give an overview of 3M's position, not going back to how we got where we are, but what we think are the critical issues today, and then address some of the points that Mr. Cool made. This is a precedential case about what it means to comply with Michigan's Administrative Procedure Act and Safe Drinking Water Act. The challenged rule set is the first time that Michigan has ever set its own MCL without the federal EPA establishing a federal MCL first. I'm sorry, I used MCL, maximum contaminant level. It's also the first rulemaking under the new procedures and obligations that created the Environmental Rules Review Committee. I'm going to focus on several key failures that invalidate this particular rulemaking. But resolution of the issues pending before you today will set the bar for what a state agency is required to do to comply with the Administrative Procedure Act in Michigan. The key issues I'm going to focus on are, first, Eagle's decision to exclude from consideration and public disclosure the costs of the rule's automatic changes to the groundwater cleanup standards for PFOA and PFOS. Eagle's reliance on an inappropriate and outdated study identifying costs estimated in New Hampshire for standards that were substantially different and higher than those at issue here. Eagle's admission that it did not prepare a serious estimate of the benefits of the rule it proposed, and Eagle's arbitrary and capricious rulemaking by abandoning fundamental scientific principles and failing to meaningfully engage with public comment in a rush to meet an arbitrary deadline. Any one of those issues independently requires invalidating the rule. But the import of this case goes far beyond this one rule. It goes to the integrity of rulemaking in Michigan. The legislature set out very specific checks on agencies in the state's Administrative Procedure Act to ensure transparency in agency rulemaking and prevent precipitous action by the agency. By hiding the costs and not doing a serious estimate of the benefits of the rule, the agency has failed to provide the necessary information for entities responsible for providing statutory checks on regulatory power. This is not a matter of a disgruntled plaintiff nitpicking an agency's rule. If an agency can say, we've determined there's a need for some kind of a rule on a subject, but we haven't made a serious estimate of the benefits of the rule we actually proposed, we claim to rely on what other states have done, but then inexplicably came up with standards outside of what those states have done. And we intentionally excluded from our analysis what may be the most significant costs imposed by the rule, then the APA has been decimated, and there will no longer be any meaningful procedural requirements for the agency in the rulemaking process. It cannot be the standard that if an agency simply puts words in every box on a regulatory impact statement, then it has done its job. And there is no good faith standard. That is not a standard. The standard is you have to comply with the act. And it's not just, well, we gave it a good try. Summary disposition in favor of the agency is only possible here if the APA's bar is lowered so significantly as to be meaningless. It is not sufficient for the agency to say or even to prove that a rule is necessary. And Mr. Cool's arguments all focus on the fact that the agency decided that a rule was necessary. The agency has to demonstrate why the specific rule it proposed is necessary under the Safe Drinking Water Act and necessary and suitable in proportion to its burdens under the Administrative Procedure Act. Defendant has failed to do that here and has not pointed to any record evidence that raises a genuine issue of material fact as to the issues raised in plaintiff's complaint.
So what does necessary mean under this statute?
Necessary means required. So in other words, when you're looking at which statute are we talking about? Safe Drinking Water Act or Administrative Procedure Act?
Just the Safe Drinking Water Act.
Right, so it means
So
required.
necessary to protect the public health.
Right, required.
Okay. Does that mean that there is a single optimal standard that the department must identify?
That is not our argument. We are not arguing that there is a single optimal standard, but the agency has to do enough to understand whether it has reached over the hurdle of making sure that the rule is required.
So there could be a range of reasonable standards that meet the necessary to protect public health standard, in your opinion?
There could be, and the key is the agency demonstrating in the record, not in post-record briefing or in litigation arguments, but in the administrative record during the rulemaking process, the agency explaining the basis for the rule, identifying and engaging in exactly the serious estimate of benefits that the agency did not do here, and in understanding what costs and burdens are being imposed.
So what are the top 3 reasons or deficiencies in what the department did with respect to the necessary standard here? Like what, because I know you have a very broad attack on many things that the department did. But with regard to the question about whether what they did was necessary to protect public health, I'd like you to focus on that and tell me, you know, the 2 or 3 most egregious things that they did with respect to that.
So if it's all right to you, I'm going to divide my answer into the Safe Drinking Water Act and the Administrative Procedure Act.
That's fine.
I think there's sort of a fundamental issue with respect to the Safe Drinking Water Act relates to the fact that the agency, it constrained its review of the science to a subset of studies and issues, which it freely
So it
admits.
cherry picked the evidence.
It cherry picked the evidence, and then it did not, and then it came up with conclusions that were different than the evidence that it reviewed. Then it did not.
Well, hold on a second. You said it arrived at conclusions that were different than the evidence that it looked at, but those are 2 different concepts. There's the evidence and then the conclusions drawn therefrom. So are you saying that they cherry picked the evidence? That's, I think, the first one that you started with. And then secondly, that the conclusions they drew from that cherry picked evidence were not properly drawn. The evidence didn't support the conclusions. Is that what you're saying?
Essentially, what
Okay.
happened was that the evidence that the Science Advisory Work Group primarily looked at was, as Mr. Cole explained, was what had been reviewed and adopted by other states. And what I'm saying there is that already significantly limits the universe of information that the agency is reviewing. So that's the cherry picked piece of it. And then what happened here is that the Science Advisory Group reached conclusions that were, in most cases, lower, by far lower than any other state had reached. And there's, I'm going to point you to something in the record, not necessarily for right now, but there's a nice set of charts.
Well, wouldn't the department maybe come back and say that while those states did a nice job of gathering evidence, they drew inappropriate conclusions and set the standards too high? I mean, I get that drawing evidence from other states might be helpful because that's at least a body of evidence that you can look at and it may apply to Michigan. But the conclusions to draw therefrom really is the province of our department, not New Hampshire's department or some other state's department. So why is it inappropriate? Why is it inappropriate solely for the department to have come to a different conclusion?
It's not, our argument is not that it's inappropriate, that the agency couldn't have reached a different conclusion. The problem is that the agency didn't comply with any fundamental scientific principles in doing that, including the fact that it did not subject its review to an independent peer review. And when a commenter, the Michigan Manufacturers Association, did engage an independent scientific peer review and submitted that to the agency disregarded it. And that peer review had substantive recommendations to make, and the agency did not engage in that analysis itself. That is a fundamental aspect of any scientific decision, is to engage in that peer review process.
What was the makeup of the independent peer review board? Was it drawn from manufacturer? Was it drawn from academia? Was it drawn from what?
I don't have that at the ready because it wasn't, 3M was not involved in that independent peer review, but I have it in my record over here, and next time I come up, I can tell you.
Is it part of the administrative record?
It is.
Okay, that's fine.
It is. So we were talking about, that's the Safe Drinking Water Act, some of the key sort of critical issues there. On the administrative procedure side, I think one of the most clear and most egregious issues here is the fact that the agency made a deliberate decision not to consider the costs of groundwater cleanup standards that are automatically imposed as a result of adopting the MCL, the maximum contaminant level of the rule in place here for PFOA and PFOS.
Is this with regard to the, if I recall correctly from the briefing, there was discussions about an estimate of $300 to, we're not talking about the $300 to $600 range.
No,
We're talking about a different issue.
different issue.
Okay.
Yeah, that related to sampling costs, those
Yes.
$300 to $600.
Okay. So you're not talking about sampling costs.
I'm not talking about sampling costs. And just to emphasize the point, defendant seems to be articulating a concern that if Your Honor reviews what they did here and comes to the conclusion that it was not sufficient, then anybody can come in and nitpick any, you got a decimal point out of place, you're out, you've got to go back and start over. We think there are a lot of problems with the rule, but that's not sort of, and they're laid out in our briefing, but I'm focusing today on really incredibly significant issues that fundamentally undermine the validity of the rule.
Okay. So what is the cost that you believe were ignored?
So under Part 201, when the state sets a maximum contaminant level for a substance for which there is already a groundwater cleanup criteria. So out of the 7 PFAS substances regulated under this rule, 2, PFOA and PFOS, already had groundwater cleanup standards in place before the rule was promulgated. The effect of the rule, which Eagle knew, and it's replete throughout the record, the effect of the rule was going to be that those changes to the groundwater cleanup criteria would automatically become equivalent to the MCL, the maximum contaminant level established by this rule. So there was no additional legal process for that, no additional opportunity for public comment, no additional information provided by the agency whatsoever as to those costs. And Eagle made this decision, the defendant, trying not to use the acronym.
We can use Eagle.
Okay. Eagle.
EGLE for our.
Eagle's decision not to consider these costs and not even identify them, they didn't add them up and say, well, that's for somebody else to worry about. That failure drew numerous questions and comments in the record from the Environmental Rules Review Committee, from JCAR during the rulemaking process. JCAR sent a letter to Eagle saying, you really need to evaluate these costs. We need to understand these. Eagle was well aware of this concern, but it just decided that it didn't need to consider the cost of environmental cleanups because those costs would be imposed through a different statutory mechanism. But it made that decision knowing that there would be no separate rulemaking process to establish groundwater cleanup standards for PFOA and PFOS. And even though it knew the numbers of sites it estimated might be impacted, which it cited those numbers when it announced this rule that's being challenged today, and Eagle had the ability to work with other state entities to identify average costs of remediation, but it did not do any of those things. There is no assessment of this in the impact statement.
Where do I find in the APA or the case law interpreting and applying the APA or a requirement that a department look not just at the costs that will be incurred as a result of rulemaking under a particular statutory scheme, but also potential costs, indirect costs, third-party costs that may be incurred under a separate statutory scheme?
Well, respectfully, I believe that these are direct costs of the rule. The legislature saw fit to make sure that groundwater cleanup standards, once a maximum contaminant level is set under the Safe Drinking Water Act, that the groundwater cleanup standards automatically become the same as the maximum contaminant level. And the reason for that, my understanding is because maximum contaminant levels apply to public drinking water systems. Groundwater cleanup standards is the way that the agency is able to address private drinking water and in remediations as well. So the legislature made a decision that those should be equal. The problem is, if these are not considered costs of this rule of setting a maximum contaminant level, there is no evaluation at all of what those costs will be, whether they are appropriate, whether they are overly burdensome. And without evaluating those costs, this is probably the most significant cost that this rule is going to impose. And the agency did nothing to consider it. It's hard to understand how an agency could say it didn't make a serious estimate of the benefits of the rule that it proposed, and it deliberately excluded the most significant costs. There's no agency discretion in whether or not to adopt different groundwater cleanup standards.
Where is the evidence in the record that I'll find to support your assertion that that the costs you're talking about right now are the most significant costs of what the department did?
Well, there's no evidence in the record because the agency did nothing to look at the costs. But what I'm representing to you is from my personal experience as an environmental lawyer, and also I think there's publicly available information.
I mean, I'm limited by Supreme Court case law to look at just this record. I can't look at things outside of this record in terms of the evidentiary basis for why the department did what it did. The Michigan Supreme Court has been extremely clear that I'm constrained by the current administrative record. With that said, was there, this issue, I don't think is a novel one. And was this not brought up during public comment and evidence put into the record during public comment showing at least a back of the envelope estimate of what these significant costs would be?
I'll have to double check. I'm not aware off the top of my head of any kind of back of the envelope calculations. What I am aware of, and which is very clear in the record, is that numerous commenters, raised this precise issue and said, Eagle, you have not evaluated the costs of this, and they may be significant. We don't understand what the implications are going to be in terms of the program. The Environmental Rules Review Committee raised the exact same issue, expressed concern about it. Even after they approved the rule, they sent a follow-up letter to Eagle saying, you need to look at the costs of this rule of Part 201, and you need to explain what is going to happen when this rule is implemented. And JCAR did the same thing. And every step along the way, Eagle said, we don't need to.
Then JCAR allowed these rules to go into effect.
They did. And this court is the last check on whether or not that was appropriate to proceed without information that public commenters, the Environmental Rules Committee, and JCAR all identified as critical to understanding the implications of this rule. And this is, to be clear, this is a legal question. This is not, the agency does not receive deference on whether or not it needed to consider these costs. This is a legal question of whether costs imposed directly, automatically imposed with no further legal process, imposed as a result of statutory requirement because of the rule promulgated by the agency, must be considered by the agency in evaluating the impacts of its rule. The APA says yes.
The APA says yes, where?
The APA requires the agency to consider direct costs of the rule.
Okay, and your argument is that direct costs are not necessarily limited to the specific statutory provision under which a rule is promulgated, but could also include legally directly tied costs that will be incurred as a result of whatever rule is promulgated. Is that a fair summary?
Yeah, I think
Okay.
it's the fact that these costs are automatic There is no
They
further
legally
agency-
flow
Exactly. They are
from
a
whatever
direct,
rules promulgated.
exactly. They are a direct result of this rule. The agency has no discretion to set a different standard for groundwater cleanup criteria.
Now, if the department had looked at these costs, considered them and said, we don't find them to be significant, that you would have a different argument in that instance. Is that correct? Your argument right now is that they didn't look at it at all.
Correct.
They just ignored it.
Correct.
If they had looked at it and come to a different conclusion, you may have had quibbles about that conclusion, but that's a different argument than the one you're making right now.
Hypothetically, if we did have quibbles about that, it would be a different argument. It's the difference between, I think what, Mr. Cool is concerned about is the agency having every factual decision or evaluation that it makes be nitpicked by the commenters and the agency unable to move forward with any rule because it's constantly, you put the decimal point in the wrong place. That's entirely different than what we're talking about here, where the agency just entirely disregarded a whole section of costs. And just for perspective, what is in the record is the number of sites that the agency anticipated would be brought into the groundwater cleanup program as a result of the changed standards. And for perspective, it is, I believe, there were 22 public drinking water systems that the agency anticipated being brought within the scope of the rule. There were 42 remediation sites that would be brought in through the groundwater cleanup standards. So, in terms of significance, just by numbers, I don't
But
have.
a remediation site can be not that big. I mean,
And it can be huge.
and it can be huge. No, I don't disagree with you. I'm just saying,
Right, and we don't know.
we don't know. Okay.
We don't know. So the next issue that I would point out under the Administrative Procedure Act is that this relates to the New Hampshire cost study. And Eagle's estimate of costs and of treatment based on the rule were based on an outdated New Hampshire study. And the issue here is not just that it was, a year old or anything like that. It's that study evaluated the costs of treating to a different standard, a standard that was significantly higher. And although our contention is that Eagle should plainly have been aware that New Hampshire had lowered its standard and revised its cost analysis substantially upward, there's a chart in the record of the cost differential between what New Hampshire originally estimated and what it ultimately did. And the difference is so substantial because when you're talking about regulating at the levels that the agency is talking about here, 1 part per trillion, that's the equivalent of 1 drop of water in 20 Olympic-sized swimming pools.
The problem that I have with this argument is that this does require me to look at matters outside of the administrative record. I get the argument. If the argument is the New Hampshire cost estimates are simply an opposite because there's a different standard. And of course, the costs associated with analyzing a different standard and monitoring a different standard are simply going to be different when you have a different standard. I get that argument. But to say that it's outdated and there's a new one that I should take into consideration, I mean, my hands are metaphorically tied here by Supreme Court case law saying I cannot look outside of the administrative record. So I get the first part of the argument. The second part of the argument where you want me to look at what New Hampshire has subsequently done, I don't think I can do that.
I think you can, and let me tell you why. The agency is bound to its record. The agency can't, and I believe what the Supreme Court case law says about this is that the agency can't look outside of its own administrative record to justify its decision-making. But a challenger to a rule has to be able to point to evidence outside the record.
I will just quote you, quote, judicial review of an administrative rule, which I think is what we have here, is limited to the administrative record and that the administrative record may not be expanded by a remand to the administrative agency Michigan Association of Home Builders versus the Director of Department of Labor and Economic Growth, 481 Mich 496 501 2008.
Right, and I'm familiar with the case and many others like it. That it's a fairly standard thing in this type of administrative procedure that there is a closed administrative record. That does not mean that a challenger can't point to something outside the record. It's the only way to demonstrate that something is missing from the record. If I can't, as a challenger, say, the agency didn't consider this over here, it didn't include it in its record, but it was right here and it was pointed out to the agency, then
That's different. That's saying at the administrative level, we told the agency about this and they ignored it. That I can't necessarily look at that evidence that you're telling the department or the agency to look at, but I can consider the fact that they were told about other evidence and they ignored it. That I can do. But the problem that I have with your approach is that would be an endless exercise, because you can always point to something that they didn't look at. I mean, that's the universe of what they didn't look at is infinite.
agree. I agree with that.
And I mean, especially in this, this kind of case where the evidence evolves, tomorrow you could bring a new case saying, well, they didn't look at today's evidence. And then the next day you could, so I guess what I'm saying is I get the argument about the New Hampshire, but I wouldn't belabor the point too much about what the new evidence shows, because I don't know that I can look at that.
That's understandable. And I think that what is in the record is clear enough anyway, because the record indicates that multiple entities highlighted this issue, the issue of New Hampshire's study looked at different standards. And that should have triggered the agency to look at the New Hampshire study. The agency knew when it reviewed the study that it's looking at different levels of treatment because there are different standards. So even if you ignore the subsequent study, that New Hampshire study is the key study that the agency based its cost estimate of treatment on. It's the primary study. And it is clear that the agency did not take into account the differences in levels between that study and what it was proposing. So either Eagle should have revisited its analysis, or it should have explained why it applied estimates that didn't align with the MCLs that it proposed, but it did not do either of those things. And that is plainly in the record. There's no question about that. And this is a key difference from the Oakland case, where actual costs were used for an estimate. These New Hampshire costs cannot be actual costs because the standards are substantially different from the one used in the cost analysis that it was relying on. The last issue related to the Administrative Procedure Act is related to the agency's failure to make what it called a serious estimate of the benefits of the rule. What the agency said during the rulemaking process, and even standing here today, what the agency is telling you is that it determined that a rule related to PFAS was necessary. That is wildly different than saying it determined that this rule is necessary and that it made a serious estimate of the benefits of the rule it actually proposed. If the state agency can just explicitly say, we didn't make a serious estimate of the benefits of the rule we proposed, then the APA's requirement to estimate the primary and direct benefits of the rule doesn't have any meaning.
Does the estimate have to be quantitative in nature?
The regulatory impact statement asks two questions, question 29A and question 31, both of which ask for both qualitative and quantitative analysis of benefits and costs.
So the regulatory impact statement can list the qualitative benefits, matters that are maybe not easily quantified. But then it does ask for, of those benefits that can be quantified, for example, maybe actuarial life expectancy impacts, those calculations, those should be quantified, is what you're saying.
That's right. The questions.
And if I recall correctly, there were, Am I correct to say that there were no quantified estimates with regard to benefits here?
No quantified estimates, and not even any qualitative estimates as relates to the specific rule. There were estimates about general statements about this rule is likely to improve public health. A rule is likely to improve public health. It doesn't tie any of that analysis to this is the level we set because we think there's going to be X benefit to setting it at this level, whatever that level is. There's nothing. There's absolutely no analysis there on either really a qualitative or quantitative level. The agency just made a general proclamation and did not evaluate the estimates, the benefits of the rule. And the language in the regulatory impact statement, where it says qualitative and quantitative, it doesn't even say where you can't do it. But I think that's a reasonable reading, where you can't do a quantitative estimate, put your qualitative estimate in there. But the agency didn't even show that it couldn't do a quantitative estimate. It just did nothing.
Are you aware, since we are talking outside the record, of other states that have found quantitative benefits or have estimated quantitative benefits from whatever standard of PFAS measure, maximum containment levels that they've set?
I am aware of other states that have attempted to evaluate on a quantitative basis, and at where they were not able to do that, because it's not always possible. Although there are, EPA does this, and it has standard procedures for doing this sort of quantitative benefits estimate.
Sure, I know. I understand that, the modeling is out there.
Yeah.
But with regard to PFAS, I guess my question is the science still relatively new, but the concern relatively high that agencies are making the decision of, while we may not be able to calculate with any kind of reasonable certainty, quantifiable benefits and costs, there's too big of a risk not to do something. Is that even a viable approach in your opinion?
I think that is an insufficient approach, and the reason is this. That is a justification for setting a rule. That's a justification for saying we're concerned about PFAS. We think something needs to be done. The next step is, what are we going to do? And what are the costs of that? And what are the benefits of it? The agency should have some understanding of what it means for the public in terms of level of health protection, cost associated with that. If the agency could set a standard at 10 parts per trillion or 100 parts per trillion, and just to be clear, I'm just throwing random numbers out. If it could set a standard at either of those two levels, and it determined that there was basically identical health benefits, but $100 million more in costs to set it at 10 parts per trillion than 100 parts per trillion, that doesn't mean that there's a magic level at which the agency has to get it exactly right. What it means is the agency has to understand the implications of what it's doing. It has to have some sense of, am I getting a benefit and an additional benefit, an incremental benefit at setting it at this level? That also doesn't mean that they have to evaluate 10, 11, 12, 13. They don't have to evaluate every level, but there's absolutely no attempt here to understand the relative public health improvement, to the extent that there is some, related.
During the public comment period, or I guess any other period during the administrative review or the administrative rulemaking process, did 3M provide or agree with other estimates of benefits, estimate of costs, appropriate standard levels? Is there a standard level? Is there a level of quantifiable benefits, a level of quantifiable costs that 3M or one of another entity that you agreed with offer that up during the rulemaking process?
I'm not aware that that entities were that anyone during the public comment process was offering up a specific level at which an MCL should be set or not set.
So there wasn't, for example, a manufacturer didn't come forward and say, hey, Eagle, you're not quantifying these benefits properly. They can be quantified, and here's, a suggested way of doing it, or here's an estimate that other states or we think is reasonable. Something like that was not offered up that you're aware of.
I believe what was offered up was there were many commenters that, including 3M, that said, you haven't done a proper, you haven't quantified the benefits and you haven't done a proper analysis of the benefits. And I believe that there is in the record information about how such could be done, for example, by pointing to EPA's experience for the methodology for how to do this. Whether anybody pointed to a specific state, I can't tell you standing here today. I just don't know off the top of my head.
Are these concerns that you're raising going to be inherently existing anytime a department is faced with a new risk that it just hasn't had much experience with?
I think this is actually a critical question because it really relates to, there are going to be new risks that agencies have to grapple with. And so what is the standard when an agency is going to undertake rulemaking? And I think the fundamental standard that the APA requires is that the agency be transparent, be diligent, and do its best to understand what the impacts of its rule will be, both positive and negative. And I don't think the agency did that here. I just want to quickly look at my notes, see if there's anything I wanted to mention. Just to correct the record, it is not correct that 3M has challenged every other state that has proposed a PFAS MCL. That's just inaccurate.
Which states did it right, just for the record? Colorado, your home state.
Colorado doesn't have a level quite yet. We have not challenged the standard in Massachusetts, Vermont. I don't know. There's
That's fair. Okay.
but it certainly has not been every state. That's just that's
Hyperbole.
hyperbole. And the agency's defense of its actions here is to attack 3M as disgruntled or self-interested. The truth is that every single complaint that 3M has identified in its complaint, in its briefing, those are all concerns that were raised not just by 3M, but by numerous other commenters, by the Environmental Rules Committee, by JCAR, and sometimes by all of those. So the characterization of 3M being, we can just dismiss their concerns because whatever, they're self-interested or they're disgruntled, it's just dismissed, it's just dismissive. It doesn't make the concerns not real. The other thing that I would just mention is that there was a discussion about, well, the rules have been in place for 2 years. Having a rule in place for a year, 2 years, 10 years, that doesn't make it a valid rule. It was timely challenged. It takes time to work through the courts. That doesn't make the rule doesn't become more valid the longer it's in place.
No, and I don't want my question to suggest that. I think what it might indicate is that there may be additional data that, again, when we're dealing with a relatively new risk that societies are trying to figure out how to grapple with and appropriately regulate, more evidence is better than less. And my only point was there may be now 2 years worth of evidence in Michigan that we can, that the department or 3M can go back and reevaluate. But that's completely separate from this case, which this case has to be reviewed on its own merits. But that was my only point.
Right, understood. I know I said this was the last thing, but here's the last thing.
The really last thing. Okay.
The real last, that was penultimate.
No problem.
Defendant has argued that no Michigan court has invalidated a rule based on a deficient regulatory impact statement. But I'm not aware of a case in Michigan where the court has been presented with a regulatory impact statement where whole sections of a cost analysis were just excluded, or where the agency said we didn't make a serious estimate of the benefits. In other words, there's no analogous case, period. And to the extent that
But
Oakland
real-
County is,
But really, wouldn't that, I mean, I get why you say that also impacts the statement, but I mean, your argument goes more fundamentally to the entire process. If the estimate, if benefits and costs had been appropriately estimated, and everyone agreed that the department had appropriately estimated them, and for whatever reason, the regulatory impact statement just didn't have a sufficient discussion of those, I don't know that we would undo the entire administrative rulemaking process here simply because the regulatory impact statement should have had some more footnotes in it. So my point is, or the way at least I see this, is your argument goes to a more fundamental issue that benefits and costs were not sufficiently reviewed here, whether or not they made it into the regulatory or impact statement or not. Is that
that's right.
fair?
In other words, the record reflects the same thing as the regulatory impact statement.
That's in that, okay, that makes sense.
I'm sure you've heard quite enough from me, so I'm going to sit down for
Okay.
now.
Thank you.
Thank you.
Thank you, Your Honor. Let me just work through some of the points that were made. Starting out with the Part 201 rules and why those were not addressed. This was not an issue that was hit. It was discussed extensively at the meetings with the Environmental Rules Committee. It was discussed with JCAR. And it was clear at the time that Eagle believed, because these rules were focused on drinking water, Part 201 was a different thing, that they didn't feel that they had to address it in this context. But because everybody knew that they were going to pass new rules for Part 201. That process happened. They issued a regulatory impact statement. 3M commented in details on it, and those rules were passed again. So it happened. Everybody knew.
But to be, I guess, I didn't know, but I wasn't in the room. So when the Part 201 rules were promulgated, do you know whether during that promulgation period, the department basically said, well, we're bound because, you know, these other standards were set in this other rulemaking, so we can't do anything about it, tough luck? Or were the costs that were going to be imposed on 3M and others like it taken into consideration in that, explicitly taken into consideration, estimated, you know, calculated? Is that in that administrative record?
I don't know the answer to that question, but they would have had to prepare a regulatory impact statement. And that would be one of the topics they would have to address. I would also make the point that there's 7 PFAS analytes that were identified to set these health-based values for. Only 2 of them would apply to Part 201. And that's my understanding. This is Mr. Oswald, who's the head of the drinking water division, was in charge of the rulemaking. That because there had been previously advisory levels set for those 2 of the 7 analysts, those would apply in the Part 201 context. The other 5 didn't have these advisory levels set. So those standards would not apply in the groundwater.
So even if the Part 201 cost had been explicitly dealt with here, it would have been with regard to 2 standards, not 7 standards.
Correct.
Okay. My guess is 3M's going to say those 2 standards were very important and very costly, but I get your point that numerically only 2 out of 7 were relevant here.
That's right. And even under their argument would be subject to invalidation. The other 5 would not be. There is some evidence in the record about this issue. It was addressed by the ERRC, the Environmental Rules Review Committee, at its meetings of let's see, October 31 and November 13 and November 14. But it was also addressed in the letter that the Environmental Rules Committee sent to JCAR on March 23rd, 2020. It's Exhibit 17 to our brief. And specifically with respect to this issue, they expressed the reason why they discussed a Part 201 and why they didn't think it was a relevant consideration is because for these two standards, nobody believed that anybody would conduct a cleanup under those two standards. Because under Part 201, they have MCLs and you can do a cleanup to that standard. If you have groundwater contamination, you have to clean up the groundwater till it's below the MCL, the maximum contaminant level. Or you can do a risk-based response. And so if you have, for example, if you have an airport where there's a spill and it migrates offsite under a subdivision and impacts their groundwater wells, instead of cleaning up all of those groundwater wells, which would be expensive, instead you can have municipal water run to those residents, and which would be substantially cheaper. That's what happens all the time. So the belief was
That remediates the health concern. That does not necessarily remediate the property value.
that's correct, which is why you then have a right to bring a lawsuit. But under Part 201, that's one of the options you have available to you. So all of this was aired before in public comment. It wasn't ignored. You even had handouts they passed out on this topic.
So what would have happened, hypothetically speaking, if in the Part 201 process, the costs imposed by these two maximum containment level standards that were imposed under the Safe Drinking Water Act, what if it had come back and the Part 201 analysis came back that costs were going to exceed benefits and therefore we shouldn't adopt this rule?
Well, I know they didn't because they did adopt those rules and they've now been passed and enacted.
Right, but I guess I'm thinking of the counter example of, so, I mean, because the way that I'm understanding your argument is in this Safe Drinking Water Act rulemaking process, we didn't have to, the department said essentially, I'm paraphrasing, we don't have to consider the costs to that will be imposed on these two maximum containment level standards because they're going to be addressed in the Part 201 rulemaking process that we're going to start up, or we're doing, soon thereafter. But my question is, that might make sense if the costs don't exceed the benefits in that Part 201. So you would have done the same, the answer would have been the same regardless of whether you consider the cost over here, the cost over there. But what if at some point the Part 201 comes back and we find out that these costs are astronomical and the benefits, we come to find out, are not that significant? How do you go back and then undo what you did in the Safe Water Drinking Act case?
Well, in that case, if the
rulemaking case.
Yeah, if the Environmental Rule Review Committee would have said, no, we're not going to approve those because of this cost. That's part of the analysis that they undertake. Then presumably somebody would have pointed that out and they would have went back and looked at these rules. If JCAR had said, no, we're not going to allow these rules to go into effect because of this issue, I can't imagine there wouldn't have been additional analysis performed on this.
Do you happen to know when the Part 201 rules were promulgated?
It was fairly recently.
Okay.
I think within the last 6 months.
Okay, so early 2022, late 2021.
That's my best estimate, yes.
Okay.
So again, this wasn't an issue that was hidden. It
But
was
again, sorry, I don't mean to keep,
Mhm.
as you can tell, I just spout out questions when I think of them. Is there anything in the law that you're aware of, either statute or case law, that says that an agency can ignore direct costs that it knows will be imposed because those direct costs will be taken into consideration in a parallel or subsequent rulemaking process.
No, nope, I wouldn't hesitate to say anything to the contrary. Again, that's just the explanation as to why it was done this way and why the Environmental Rules Committee and JCAR decided to accept that. And as you can see, there are lots of analysis of the direct and primary benefits of the rules. It doesn't say all, it says estimate the primary and direct benefits.
So
And
under
the
a
focus-
under a part 201 rulemaking process, what are the, just very high level, what are the benefits that are looked at there?
Well, it's probably going to be the same also, which is protecting public health.
I mean, are we basically double counting the benefits? You get the same benefits in Safe Water Drinking Act, same benefits in part 201, but we're not willing to look at the same costs that are going to be imposed in both?
I have to repeat that question for me. I think
Sure.
that there's different PFAS analytes and they all have different levels. And so again, they were looking at, all right, what are the health risks of each one of these, because there's thousands of these PFAS analytes. And they identified just 7 to focusing on it where they had evidence to show there was a risk of harm. That's how they came into the analysis. But if you're asking this goes to the question you're asking about, how do you estimate the health, the impact, the direct benefits of these health based values? You can't do it. And Eagle didn't hide from it.
Well, I mean, I get that you might not be able to estimate every potential benefit because there might be, some benefits that are just qualitative in nature, happiness. I don't know that you can quantify happiness, but if you have enough data, you certainly could say, well, if we keep it at this current standard, the actuarial tables tell us that this number of people will die earlier than what they otherwise would. If we set it at this standard, a lower number of people will die because of exposure to this. We have actuarial tables that put a number on a human life. We do that. Insurance companies do that every day. That's at least something to look at.
You're right. In this case, though, the problem is the hazards of this chemical have only become recently known. So that type of information doesn't exist.
Okay.
But again, Eagle didn't hide the fact. They addressed it right in their regulatory impact statement, paragraphs 31. They said exactly this. They addressed it. They explained the shortcomings of their analysis, why it is they couldn't do this. It was subject to public comment. It was subject to review by the Environmental Rules Committee. It was subject to review by JCAR, and it still passed.
And if that is it paraphrasing your argument to say that if that is found to be deficient, then we really can't have regulatory rulemaking with regard to emergent risks?
Exactly. Yes.
Yeah.
There was an argument that Eagle cherry-picked these standards, and that's just not.
I think the argument was that you cherry-picked evidence.
Cherry-picked evidence. Yeah. That's what the work group was directed to do. The work group
cherry-pick evidence
was to look at these standards.
look at different.
Again, because that's exactly what the directive from the governor was. Look at these other standards. This wasn't a decision by Eagle. This is the directive from the governor. Look at these other standards. We've got to move fast. We have Wurtsmith Air Force Base. We have Wolverine over in Grand Rapids, where there's contamination in people's drinking water. We have to do something because EPA isn't acting. And so they couldn't undertake a year-long process and just let people drink this water. They had to do something. They had to do something fast. And so where do you have available evidence? By looking at what other state and federal agencies have done. They've went through this process. They complain about lack of peer review. The EPA doesn't require peer review, and most of the reports that they relied upon, the work group relied upon, were peer reviewed. So you don't got to peer review a peer reviewed study.
What criteria did the department use for selecting states that it that it considered?
They told the work group to look at all
All states that had some regulation.
specific to these PFAS analysts, yes. Yeah, and federal government. Not only that existed, but proposed standards.
So it's not
that
as
existed.
if you said, or the department said, we're going to look at these two, but we're not going to consider these 5 states that have PFAS standards. It's, we will look at any state that has a specific standard with regard to these 7 contaminants.
And I think it's clear that the work group even went beyond that. Again, because this information is developing so quickly that in situations where they found reliable scientific data that now existed that showed that the data these other states may have relied upon if they passed their rules 5 years ago, 6 years ago, 7 years ago, there's now new data out there. And if that new data established that is scientifically defensible, that a health-based value should be at this level, they did look at that too. So it wasn't just limited to, the work group didn't just limit itself to what other state and federal agencies had done. But again, that's why there's this direct correlation necessary. They relied on the report that the work group did, which established these health-based values. That is the direct correlation to how Eagle was able to determine these standards were necessary to protect public health. We talked about part 201, and there is evidence in the record about how or why it wasn't in the report. It was fully aired. It was fully addressed, public comment, and before the Environmental Rules Committee, and it was addressed in the letter to the JCAR. Everybody was aware of what was going on. And yet the rules were still allowed to go into effect. With respect to the New Hampshire study, yes, it's right in our regulatory impact statement that Eagle relied upon the initial New Hampshire report. During the time that the public comment was occurring, New Hampshire issued a new report and nobody brought it to Eagle's attention. Eagle wasn't aware of it.
So is the new or the revised New Hampshire report anywhere in the administrative record?
No. So it's information outside the record. It wasn't something that Eagle relied on or even considered, and therefore it's inappropriate to raise it at this time. I would also say, you know, the assertion that Eagle solely relied on the New Hampshire report is incorrect. And that if you look at our regulatory impact statement in paragraph, let's see, 13, and then which relates to the cost, and discuss the cost for installation, operation, and maintenance. But on the next paragraph, paragraph 14, there's a continuation of the response to question 13. And in that section, Eagle also points out that not only are we relying on these New Hampshire estimates of cost, but we have our own data available to us. The New Hampshire estimate for large systems was roughly $7.4 million. But on the next page, Eagle points out that the city of Plainfield was installing GAC treatment in response to contamination, and their estimate had come back at $15 million. So Eagle wasn't solely relying on the New Hampshire report. They also showed other data which showed the cost could be almost more than twice as much as the New Hampshire data.
You know, I think opposing counsel made the point that, yes, I mean, one of the arguments is that there was this revised report that should have been taken into consideration. I get your argument that that was never brought to your attention. But what about the ancillary argument that even based on this original New Hampshire report, you're really comparing apples and oranges because that report was based on a different maximum containment level standard, and the department should have understood that the cost would be different with a more stringent standard.
No, that's the argument that they make, that the standards are different. They are different. a part per trillion here, a part per trillion there. You heard the argument about a drop in a swimming pool. Yes, they're different. Are they really significant? What evidence has been submitted to show that in fact they are significantly? I would tell you, Eagle and our scientists would say, no, they're not significantly different. They're very similar. So we believe that's really a false argument that they're asserting.
Is there anything in the record that suggests that Eagle at least identified that as an issue and indicated that, yes, these standards are different, however, we believe the costs are comparable?
I can't think of anything off the top of my head that says that. Well, maybe the work group's report, there might have been a quote that they didn't believe that there'd be significant. Yes, they admitted there were differences between the standards, but they didn't believe they were significant.
Okay, we'll take a look at that. Thank you.
And we talk about what is the benefit. The benefit is public health. You know, well, they didn't estimate the benefits. No, throughout our regulatory impact statement, we talk about it, that the benefit is to public health. I mean, that's where we start.
I know, but you can't just, I mean, it's not sufficient just to continue to use the phrase public health. I mean, you have to show some improvement to public health in some qualitative definite way or quantitative definite way, or some negative impact that will be averted.
Exactly. I could not agree more. But that's what the work group's report did.
Okay.
And they set it out in excruciating detail in the tables that are attached to it. What the levels are, what reports they relied on, and what the adverse health impacts that they were trying to avoid.
So I just want to make sure that you're not arguing that Eagle can do whatever it wants as long as it says, well, this is public health. You're indicating, I think, that if I look at the work group report, if I look at the impact statement, I will find those very specific qualitative, maybe even quantitative benefits.
Absolutely. Yes. And again, we talked about no serious justification of the benefits. This was an issue that was discussed substantially. It wasn't hidden. And I think it's important to note that there is no other state agency that has a commission that sits over its rulemaking and reviews it.
Are you talking about JCAR?
I'm talking about the Environmental Rules Committee.
Okay.
Eagle is the only state agency that has such a department. So before a rule can even get off the ground, before it can even go to public comment, the legislature has appointed this agency of environmental groups, of manufacturers, of state departments to look at whatever Eagle is doing and makes them justify it. So there's this extra level of a rule of review that no other state agency has. And yes, I don't think the statute says that what the Environmental Rule Committee means this court has to follow. But the fact that this entity exists and is going through this analysis and still approves these rules should give you greater confidence that in fact the procedures were followed. And so I'd ask you to take a look at that and again emphasize that JCAR had the opportunity to step in here. They didn't do that. These rules were enacted. So in fact, it wasn't Eagle just out on an island here. There was substantial review by other outside entities.
And you may have already answered this question. I apologize for belaboring the point. Is there something in the record, maybe in response to then Senator Lucido's letter or some other comment either from this committee or from JCAR, where the department said with regard to these costs that we're being told that we haven't properly taken account of for, we are going to do so, but it's going to be part of the Part 201 process? Is that explicitly in the record somewhere?
I think that's Exhibit 17. That's
Exhibit
the letter that the Environmental Rules Commission, Chairman of the Environmental Rules Commission, sent to JCAR.
Okay, good, thank you.
Unless you have any other questions, I think that's.
I don't.
Thank you, sir.
Maybe just for the record, if you wouldn't mind putting in the date and the to and from.
Sure, this is, it's a March 23, 2020 letter. It was from Rob Niederhood, who is the chairman of the Environmental Rules Review Committee. I think you cited it in your brief, actually, and so it should be an exhibit to yours also. And it was sent to the Joint Committee on Administrative Rules.
Okay. Does it have a base number?
Not
the one you
the
have,
version I have, fortunately.
I think I've seen that letter, so it's one that we're well aware of. So thank you. If you want to take a moment to find that letter, that's fine. Or if you just want to use opposing counsel's copy. I always get confused by that question because the question is, would you mind? And we always say, yeah, sure, which would indicate that we all mind. But it's one of those little quibbles that I have decided not to raise too often.
This is the letter from. All right, to just follow up on a few points here. One is that I think it's important to clarify the record, which I think is now a little muddled on Part 201. PFOA and PFOS automatically had standards when the maximum contaminant levels were set in this rule. Those automatically became groundwater cleanup standards for PFOA and PFOS. There are 5 other substances for which a regulatory impact statement was issued, and the reason is that those substances did not have pre-existing groundwater cleanup standards when the maximum contaminant levels were promulgated. That process did not include analysis of PFOA and PFOS. So I think that got a little bit muddled during the conversation, so I just wanted to be clear about that.
But I also want to have you address the argument that the costs that you indicate, or at least some of the costs that you indicate, were not part of this process and should have been, because the standards were set here, that those costs were taken explicitly into account in the Part 201 rulemaking process. And so I guess, one, I would like to get your reaction to, was that done? And secondly, if so, why was that not sufficient in terms of taking into account the costs that you're concerned about?
So 2 points on that. One is that no, it was not done. I'm not aware of a cost analysis, a numeric cost analysis that was done in that regulatory impact statement. And that regulatory impact statement on the process for those 5 substances is Exhibit G to our reply brief. So we have that in the litigation record here.
What about the 2 that?
There is no regulatory impact statement for those 2. That's why I'm trying to.
So the cost associated with the 2 contaminants, PFOA and PFOS.
Right.
It's your position that the costs associated with complying with those regulations were never taken into consideration in the Part 201 process?
Correct. That's correct.
Okay.
And the other point that I was going to make is the one that you made in your questioning, which is best case scenario for the agency here is that they looked at the benefits and they're counting the same benefits for two different rules and splitting up the costs. So they're double counting the benefits and dividing the costs in order to somehow get some kind of analysis where we say, well, we've got a generic health benefit and only a little bit of cost over here and some of the cost over here. And we're never going to look at that all together. That's what's happening right now. And on the cost point, it's important that Mr. Cole brought up the Plainfield example, the water system Plainfield. That was the example that the agency used in its RIS as a Michigan drinking water system that was subject to treatment under the 70 part per trillion health advisory level that was in place prior to these maximum contaminant levels. The Plainfield estimate, and this is in the regulatory impact statement and it's in numerous comment letters, was $15 million for one system to treat at 70 parts per trillion, many times higher than the standards that we have here. But the total estimate that Eagle made for treatment costs for all water systems that were going to become subject to these rules was $11 million. I just can't understand any rational basis for how 22 water systems adding up to a total of $11 million at substantially lower standards and treating more substances, how that can be true when the agency itself is citing one drinking water entity with a cost of $15 million at a higher standard. Another critical point, I think, is that defendant just stood up here and said that Eagle scientists would not say that New Hampshire standards are very different, that Michigan standards are very different than New Hampshire's original standard. But this is our point. If there is no difference in terms of benefit between those two levels, between the levels set by Michigan and the levels set by evaluated by New Hampshire in that cost analysis, and those levels were well more than double what the standards in Michigan are, then why impose the significant additional costs?
I don't know. I'd have to go back and check the record, but I don't know that opposing counsel said that the scientists would say that there's not much difference in the benefits. I think they would say that there's not much difference in the costs of monitoring.
Well, the costs, it could be that I misunderstood. The costs that were analyzed in the New Hampshire study were not monitoring costs. They may also have had monitoring costs, but the ones that we're talking about are treatment costs. And those clearly differ substantially based on the level at its set. And, defendant can stand up here and say, well, it's just a part per trillion here, a part per trillion there. But my point is when you're looking at remediating a level of one drop of water in 20 Olympic-sized swimming pools, every time you go down 1 part per trillion, it becomes more difficult and more expensive to remediate it. That's not specific to PFAS. That's not specific to any substance. That's just kind of a universal truth in remediation. And I'm pretty sure that Eagle scientists would agree with that. The lower the standard, the more difficult, after a point, the more difficult and more expensive it becomes to remediate to that standard. That's a relevant consideration. And when you're looking at a standard that's more than double what the agency is proposing and trying to base costs on that, you at least need to adjust what those estimates might be to account for it. And even if we were going to say, okay, it's fine if they use the New Hampshire study at the wrong levels, they did nothing to explain why those costs are appropriate to consider here. And numerous entities pointed out in the rulemaking process, in the comment process, that those standards are very different. What the agency looked at from New Hampshire is very different than what the agency was proposing here, and suggested that the agency need to consider appropriate and similar costs so that you're comparing apples to apples. It's plainly in the record, and there's nothing that the agency did in the record in response. Next is that, again, the benefits that are being discussed are not being tied to the levels at which an MCL is being proposed. They're just saying there is a public health benefit. And defendant is saying, well, there was all this pressure to act. There were these situations where people had contamination in their water. A couple important points on that. First of all, the agency's own data showed that 90% of wells tested during the sampling program that preceded the maximum contaminant level promulgation were non-detect for any PFAS. Second, the agency was already able to address and treat those remediation, those sites where there was contaminated drinking water. They already had that authority, and they would have that authority tomorrow if you invalidate this rule. You are not leaving people exposed where the agency is unable to address an imminent public health threat. That's not what this case is about. And finally, the APA does not relax requirements when an agency determines a need to act quickly. That is the COVID case. I have the site here. That's the case that went up to the Supreme Court on the COVID emergency rules, where the governor was overruled and said that the governor stepped beyond her authority. The governor,
If I recall correctly, that didn't involve promulgated rulemaking, did it? I believe it was the governor putting out executive orders and the Department of Health and Human Services putting out its version of orders. I just think that is an apples and oranges position in terms of the question here is whether these rules were promulgated properly.
right.
Under the APA and under the Safe Water Drinking Act. That is a different, the non-delegation doctrine is just a different issue. That's a constitutional issue. I don't believe you have constitutional claims here.
No.
So I get it. I know why you're drawing the analogy. I'm just saying it's not particularly impactful here.
Yeah, and I agree. It's not an apples to apples comparison, but that's kind of why it's important, because we're not talking about an emergency rule. We're not talking about an emergency situation. We're talking about promulgating standard related to chronic lifetime exposure.
And there is emergency rulemaking under
Exactly.
either the APA or the Safe Water Drinking Act. Am I correct?
Exactly.
Okay.
Exactly.
And this is
Not that.
not that. Okay.
Exactly. That's really my point, is that this is not an emergency. And the APA does not, even if it were, the APA doesn't change its standards, because there's other routes, to go through to get something in place in the case of an emergency.
Okay.
And then I think the last thing I want to point you to is this discussion about the Environmental Rules Committee and the role that it played in overseeing this rulemaking. As I noted, when I first got up here a long time ago, I said, the Environmental Rules, this is the first rule promulgated with the Environmental Rules Committee procedures in place. So what we decide here will have a long-term impact. I strongly encourage you, if you haven't, to watch the video of the final Environmental Rules Committee meeting, where the agency was presenting its package on the rulemaking, and the Environmental Rules Review Committee was evaluating and voting on whether to move this rule forward. It's illuminating in the sense that there were members saying, I haven't had time to read the rulemaking package. Can we get more time? I haven't had time to look at this. It seems like there's stuff missing from public comments, from responses to public comments. Why did the agency do this and that? There were far more questions than answers, and it becomes clear from watching that. And the follow-up letter that ERRC sent to JCAR, and the JCAR's letter that was sent back to Eagle, there are significant levels of concern and a rush to judgment here at every level along the way.
But did the committee ultimately vote to approve?
It did.
I mean, I've been involved in the legislative process. It's not always a very clean, rational looking process from the outside. If the committee voted, then at least half of the committee believed that they had sufficient evidence, argument to vote to approve. I mean, the committee's vote is what it is.
Right.
It's not a rubber stamp, but it's not a seal of approval. It's one step along the process. And I get that.
Right. And my only point in raising this is there were significant and pervasive concerns about this rulemaking process from beginning to end. And it's very clear from reviewing the record that there is a substantial amount of information missing. And people felt pressured to move this forward from the agency to ERRC to JCAR. And this court is the check to make sure that the agency has done what it needed to do in the absence of those pressures. Thank you for your time.
Anything else to wrap up?
Through our regulatory impact statement, and I guess, they have the question about the Part 201 criteria. And I'm trying to figure out, well, which of the categories or estimates that are required under the APA and are in the regulatory impact statement, Eagle should have responded or provided an analysis of this. The topics that are in the APA and adopted in the regulatory impact statement are very broad. Estimate primary benefits. Eagle put down a lengthy answer to that question. The fact that some may not have been addressed doesn't mean the rules should be evaluated. That's just somebody second guessing what was done. Second guessing that both the Environmental Rules Review Committee and JCAR felt wasn't necessary.
Well, and I think it's obvious. I don't know that I would get any argument from anyone in this courtroom that my job is not to second guess or to Monday morning quarterback, but it's just to make sure that everything that was supposed to have taken place did take place, and that all appropriate evidence was considered and appropriately evaluated. The only last question I have is, do you have an understanding of why the emergency rulemaking procedures were not employed, given that I think is clear from our discussion today that this was an emergent risk and maybe one that the emergency rulemaking might have been appropriate for?
Well, I think my understanding of the issue is it's not as though nothing was done for these individuals that had drinking water issues. Typically, standard practices where Department of Health and Human Services will go out there and distribute filters that would assist these people. So there's actions that could be taken, interim actions, albeit nobody wants to have to use a filter on their faucet all the time. So there's interim action that can be taken. And so again, they thought this was an important issue and they wanted to go through all the necessary steps to get good, solid rules into place. As I said, everybody knew 3M was out there and was going to challenge whatever we did.
Well, but it's different. I mean, it's one thing to say that we want to do something, but I guess, from a layperson's perspective from the outside, if there's sufficient evidence to go through the proper rulemaking, the full rulemaking procedure, fine. But if we're in an emergency situation, then we can do, I think there's a procedure for emergency rulemaking. But if I believe it's time limited. The rules aren't permanent.
Right.
They're temporal.
And before Eagle had undertaken this process to enact these rules, they had done a comprehensive review of contaminated sites in the state of Michigan and drinking water, all drinking water supplies. And so they had identified those that had issues. And it wasn't as though actions weren't taken to protect the public. And I think that's why they used a regular process. And again, because there's no time limitation.
Okay, thank you.
Thank you, Ron.
You got 2 minutes if you want to say the last word, if you're good.
The only thing I would say is just on that very last point, that there's nothing in the record that declared that there was an emergency or any other sort of emergent risk. That's just not in the record. That's part of the discussion here today, but that's not part of the administrative record. It was not considered, or at least the state didn't say it was considered an emergency as that is used in terms of emergency rulemaking.
Okay.
So thank you for your time.
Appreciate it. So I will get something out. This is a complex case. The record is thick. And so it is going to take a little bit of time. I expect that I will have something to you by sometime in August. And that's a little bit longer than what I would like after a hearing like this. It'd be nice to get something out within the next 2 weeks, but I just don't see that as possible. And you shouldn't take anything from this other than it's a busy summer. I've got other court of claims stuff that frankly just has more timeline pressures on it than this one. But I do expect to get something to you by sometime in August. And if for whatever reason there's something changes in this case that you want me to be aware of with regard to timing or whatever, just let me know. Like I said, I will do something with regard to standing. My hunch from what I've heard today is that I'm going to hear something about, well, we're directly impacted by the Part 201 rulemaking, and these costs were explicitly pushed off to the Part 201 rulemaking. Therefore, we have standing to address it here. And that's fine. That may be more than sufficient, but I would just like something cogent, brief with regard to that from both sides. And don't feel like you have to disagree. If you agree, Attorney General's office, that standing is here, that's fine. But I just want something more than what I've seen so far on that issue. Okay. All right, I think we're done and we can go off the record. Well, thank you. Thank you for coming in from Colorado. I hope I at least gave you your money's worth in terms of, it wasn't 5 minutes and you're out, and maybe that's what you would have liked, but you can say, God bless it. We were there for 2 hours. And do you get out to the flat country very often? Yeah, we don't have mountains. No, I've visited Colorado, and it takes me about a week just to get acclimated. I'm like, good Lord, I don't know how you people deal with all this stuff. Oh.
So I really had to I lived on the East Coast for a long time, and I had to get acclimated.
Yes, we like our trees. All right, well, thank you all for coming in. This has been very helpful. It's long and it's laborious, but it's